Thank you, Dr. Gauthier. I want to ask Professor Rostow just to respond to some of the points that were made in that presentation, and maybe Professor Lapidoth, you will too. I mean, the key conclusion that you said there, that basically it has been codified and got lost along the way, that the Jewish people have the right, and we're speaking at a legal panel here, to everywhere in the land. It would be interesting to hear you weigh in on that, Professor Rostow.
Well, I don't disagree with that point, but I think one could, you can have your cake and die eating it. So one has to be a little careful. I would put it this way, that the mandate for Palestine as a trust remains in effect until it is wrapped up. It is wound up as a matter of law, and it's partly wound up. It's not fully wound up. And Israel and Palestine have recognized each other, not as two states, but as sort of a state and a state. That is, the Israelis are a state, but the Palestinians are not fully recognized as a state, but they've reached territorial and political agreements. They've made commitments to each other to make more agreements, and so there's unfulfilled political obligations on both sides. Could the Israelis say, enough already, we've been dealing with you people enough, and we haven't gotten what we want, and you haven't gotten what you want, so we're just going to continue in the present situation? They could, but I'm not sure that it's a desirable outcome. If the object of the exercise is to get away from an observation Moshe Dayan made years and years ago, which is if the Jewish people want a state in their ancient homeland surrounded by countries that don't want them there, they're going to have to fight all the time. And that's not a desirable outcome, I don't think. But we've reached the point, I think, where the law is not going to solve this problem. I remember when I was in the government and one of my colleagues wanted the U.S. government to say that the settlements were illegal because he thought that would enhance bargaining position. And I said, well, if you say they're illegal, then the argument becomes how much closer to the Mediterranean do you move the 1949 armistice lines? And if you say they're lawful, how do you achieve a compromise? If the object is a compromise, one has to make the law the servant of politics, not the other way around, I would think. But it's not an easy problem to solve, and especially not when trust is very low and where the most fundamental requirements of agreement don't exist. And President Clinton discovered that at the end of his administration. President George W. Bush discovered it working the problem. I don't know what President Obama discovered.
Professor Lapidoth.
I have a few remarks, and I'm not sure that they will answer all the questions. First of all, with your kind permission, I would quote Nick's father, Alav Shalom, who used to say that the West Bank is an area of the Palestine Mandate whose future has not yet been decided. Nahon, this is what he said. Secondly, I would like to mention, if you look at the Torah, you see that the boundaries of the old state of Israel and Judea were not always from the sea to the sea. There were different kinds of borders, and it's interesting, by the way, when you have Shnat Shemitah, the things that are grown in the area of Eilat are not subject to the limitations of the Shemitah, because this is not considered to be part of historical Palestine. So that Palestine has different boundaries in different times and for different purposes. I would like to mention one additional remark. We have spoken here of international law as if it had been always the same. But international law can also change, and we have to look at what they call intertemporal law. So maybe things that were correct 30, 40 years ago are not necessarily the same today. And a last remark concerning sovereignty. Maybe I have said this already in our last conference. If we start to quarrel with the Palestinians about sovereignty, we will never, never reach an agreement or a compromise. Because this is a matter of, how should I say, of sentiments, of feelings, and people feel very strongly about sovereignty. Therefore, I recommend, and this is in the footsteps of King Hussein of Jordan, alav shalom, who used to say, sovereignty belongs to God, and we should not quarrel about it. We should quarrel only about powers and responsibilities and not about sovereignty in Jerusalem, because then we will never, never, never reach any kind of compromise. And I would like to make one additional remark about earlier discussions this morning, when people said that the Balfour Declaration promises a solution both to the Jews and to the Palestinians. I think that here I had an interesting diplomatic experience. There was a guy in the American diplomatic corps who did not like us at all. I also did not like him, never mind. This was not so important. And he used to say, yes, and I said, where do you have any promise for the political rights of the Palestinians? And he said, yes, because it says civil and religious rights. I said, civil and religious does not mean political. So he thought a little bit, he was not a lawyer, and he said, well, civil rights include also political rights. And of course, I did not agree with him, and I don't think that civil rights include political rights. So this was another general remark that I wanted to make about the interpretation of the Balfour Declaration.
Thank you. I just want to put one last question to the panel. This session was supposed to be, the Balfour Declaration and its applications and relevance 100 years over the 100 years that followed. So I want to ask you, as a legal question, whether Israel's legal position is weakened if we are not formally committed to a two-state outcome. Right? You discussed and you made a very powerful argument about lost commitments and failed commitments. Fascinating for me to hear that Ben-Gurion, could have cited some stuff that he didn't cite. Pretty interesting. That was quite revelatory for me. It's quite revelatory to hear you, Professor Rostow, saying the law is not going to solve this problem. Nonetheless, are we undermining our legal rights if we are not formally committed to the two-state solution? I don't know which of you wants to answer first. Please.
Well, it's an important question, and as I understand it, the Israeli government is committed to the two-state solution. So, in a way, it's a hypothetical question. And one of the fundamental problems is, as Professor Lapidoth just reminded us, it has to do with power and responsibilities. And if Israel, in my view, has marched down the road to a second partition of Palestine, and with the Palestine Authority, and it hasn't gotten all the way to the end of that road for reasons we all understand. But if it were to renounce the road as impossible to achieve now, would that be a renunciation for all time? And what would it mean for Israeli national interests as understood by Israel? That's a very important part of the answer to the question. The second thing has to do with Israel's relative power in the world. It is not a great power. And the last thing it wants, I think, is to be back in the situation Ben-Gurion found himself in 1957, which is, I have to get out of Sinai because I have to save the Jewish people. and you don't want to go there. So I can't say that the legal arguments are weakened if Israel says the two-state solution as conceived, where there's a state of Palestine on the eastern side of the armistice demarcation lines and Israel on the western side. If that's the vision and Israel were to say, no, we can't accept that, I'm not sure that their legal argument is weaker, but I think their political argument gets to be weaker. Now, the important thing, I think, is that where the boundaries are, ultimately, is, it's a territorial dispute. You can solve that problem if people want to solve it, and it can be solved as the most complicated way possible or the simplest way possible. The Washington Institute has produced a book full of maps showing how it can be done if you want complicated maps or simple maps. But you need two parties to tango, and at the moment they don't exist.
Dr. Gauthier, please.
I am not entirely convinced that at this point in time the Palestinians are committed to a two-state solution. There was a conference organized in Southampton for 2015, and there were about 50 speakers over 3 days, and the theme was the legitimacy of the state of Israel in international law. That didn't go forward, but they did it again, restructured the conference for 2016. The first one I was invited to, the second one I was invited to. Amazing, because 49 speakers were taking a very different position than mine. And that was canceled as well. Third time, this conference was scheduled for Cork in Ireland. It was supposed to start in March of this year, and it's been canceled. The purpose is to establish not that there are rights and entitlements to the so-called occupied territories or to most of Jerusalem, but that there is no legitimacy to the territory occupied by the state of Israel. So here's the problem. If you don't go on the battlefield, the legal battlefield, if you don't rebuild those walls, if there is no support for the contention that you have the right to be everywhere in Jerusalem and you have the right to remain in the Judea and Samaria, even if there's a Palestinian state, then what right do you have in respect to the rest of West Palestine?
Fine. I think many people in this room will share your concern about whether the Palestinians have ever truly committed themselves to a two-state solution in which we retain a Jewish Israel. My question really relates to whether we undermine our own claim if we are not. I mean, for decades, it was Israel's goal, concern that the Palestinians were not endorsing a solution, and therefore a two-state solution. Therefore, my question about whether we weaken ourselves by, if we were to weaken our commitment to a two-state solution. Professor Lapidoth, let me invite you to have the last word.
Oh, last word is
Sure.
dangerous.
We'll take the chance.
Two remarks here. First of all, what is a state? State, you can define a state legally, politically, whatever you want, but there are so different kinds of states. You have an associate state, you have a federal state, you have a federation. There can be so many different structures of states that you can perhaps find some kind of structure which would not do any harm to your basic claims to have the whole of the area. Secondly, you can also agree without agreeing to the basic point. For instance, the Falkland Islands, and I'm sure you have British members here in the audience who know more than me about the Falkland Islands. The Falkland Islands are in a dispute between England and between Argentina. There was a war in 1983. They have now a few agreements between England and Argentina about these islands, and they say specifically and clearly, but we do not agree on the question of sovereignty and who is the owner of these islands. So you can reach agreements without agreeing on this basic problem. So that there are ways by which you can you can make sure that you do not lose any of your claims.
Well, I think that qualifies as a slightly optimistic note on which to end. I want to thank you all for being here, and I want to thank our distinguished panelists, Dr. Gauthier, Professor Rostow, Professor Lapidoth. Thank you very much.